Good afternoon. My name is Jim Ludwig, Major Gifts Officer here at Vegas PBS, and I want to welcome you to our Plan Giving seminar today, provided to you by the Southern Nevada Public Television Plan Giving Council. Our topics today include wills, trust, and powers of attorney. We have three experts in their field with you today. First is Rob Bullock, Deb Erdman, and Patrick Clifford. Our format today is going to be a question and answer session. If you have any questions, and I'm sure you will, please provide them in the chat box. Let's meet our panelists. First, we have Rob Bullock, an attorney. Next, we have the Vice President of Peak Trust, Deb Erdman. And we have Patrick Clifford from Clifford Senior Law. Now let's get this seminar started. Probably the most obvious question we have here is, what is a will? What is a trust? Rob, can you give us a layman's term definition of what a will is?
Certainly. A will is a document that you would sign to set forth your wishes, your will, your desires for what happens with your estate, your assets when you pass away.
Okay. And Deb, can you give us a layman's term of what a trust is?
Certainly.
And how it differs from a will?
Okay. Well, certainly. So a will, you state what you want to have, and in a trust you can do the same thing, but a trust is a contract. It actually is a separate living being, and you can actually place assets inside of the trust, which you can name someone, the trustee, to control and dictate what happens with those assets and who eventually will get those assets.
Excellent. And Rob, why do we need a will?
So a will is, a lot of people think that a will is something that you can use to avoid probate. Probate is going to court. The opposite is the case. So if you have a will, I tell my clients, consider that as a formal document, an invitation to your heirs to go to court when you die. Contrast with a trust, which avoids probate. So what I tell everybody is if you like your attorney more than your kids, get a will. That ensures going to court. If you happen to like your kids or beneficiaries more than your attorney, then you get a trust.
Nice. And one thing I like to everybody know is we normally have these seminars live, and Rob is also known as the comedian of our group, and he has a phenomenal PowerPoint presentation that is in your materials that you have as well. Deb, why do you need a trust?
Well, you need a trust for several different reasons. They can be used to pass on assets to your heirs, to your beneficiaries of your choosing. They can be used for tax efficiency, for tax purposes. They can be used for asset protection trust purposes. They can be used for charitable giving. There are a lot of different functions that a trust can be used for.
Now, yeah, go ahead, Rob.
Oh, a trust, as Deb indicated, a trust acts like a will substitute. It's just you get to go private as opposed to public. You get to go on your own as opposed to through the legal system. So in a will, you would name an executor, personal representative, somebody to execute your wishes when you're gone. The terminology for a trust is successor trustee. So same person, same functions, just get to do it on your own without court supervision.
Can you give me some examples of positive experiences with wills? And let's turn that around and some, I don't want to say horror stories, but some challenges that people have had by not having a will.
Certainly. So one of the things that a will accomplish is you can name who you want as the executor or personal representative of your estate, and that person can serve without bond. So in Nevada, if you don't name who you want as your personal representative, you have to have a Nevada resident. So you have family members that are elsewhere, you want this person to do it, you can do that in the will. Here's one short example. Husband, wife, they have, say, a $500,000 estate. The assets were in the wife's name. Wife died, so the terminology there is intestate without a will. So as community property, everything would go to the husband. But she didn't have a will, and so we prepare the petition for the husband to file with the court to get appointed as the administrator of the estate. So in a will, you can waive bond. there wasn't that situation without the will, and so the court made him post a bond to protect himself as a beneficiary from what he may do to himself as the personal representative. He said, this is ridiculous. It's like, common sense is not the issue here. This is what the law says. So, like it or not, that's one example of what a will can do, is waive bond, and you can also appoint whoever you want to as the administrator of the estate.
So long story short, it's best to have a will.
Yes.
Deb, same thing on a trust side?
So I would say for a trust, the best way to utilize it would be to avoid the issues that Rob said, because inside of trust, the trust already holds the asset. It's just a matter of who controls it. So if something happens to the original person that set it up, like the grantor, meaning they pass away or they become incapacitated, there's a successor that steps in, and then they simply start taking over what happens with the underlying assets. You don't have to go to court, and you don't have to, as we say, basically air all of your assets to anybody in the public that wants to know about it.
Patrick, I see you shaking your head. You want to add something?
Well, yeah, those are very important points. The way a trust avoids probate is the court proceeding that determines who owns your possessions after you're gone. But if your trust owns it before and after, you don't have to worry about that. And that airing of all that information, which is public, is a very scary thing. Now, Tony Shea just passed away, and anyone who went on the RJ's website could pull up that petition and find out his home address, his parents' name and home address, his brother's name and addresses. I mean, what could possibly go wrong? If you want to keep that information private, get a trust, not a will.
Got it. Now, this is a personal experience from me. My wife and I had everything all set in Ohio and everything else, and she got a phenomenal job here, and I'm blessed to have this job here in Vegas. We love it here. We had everything all set in Ohio, and now we're in Nevada. Do we need to change our will, our trust, that area, Rob?
No, in a word. So a trust or will executed in Ohio is good in Nevada. One done in Nevada, you move to a different state, it's fine there. The one difference would be powers of attorney, which are state specific. So when you move from Ohio to Nevada, your will and trust would be fine. What you would need would be Nevada powers of attorney, they're medical and financial.
Okay, and we'll talk a lot about that a little bit later
yeah.
here as well. Here's a question that we had. Can my trust own property in another state, Deb?
Certainly. In fact, that's very common. A lot of our Nevada trusts that we work with have assets all over the world, all over the United States and outside of the domestic United States.
Got it.
As long as it just has to be able to, the asset has to be able to be titled in the name of the trust. That is the issue.
Got it.
So anywhere between North Pole and South Pole works.
Like Santa?
And another
yes.
reason you want to have the property in the trust is because real property, if you have real property in Idaho, you have to do a separate probate in every state where there is real property. So if you want to avoid not just one probate, but multiple probates, put it all in the trust.
Now, you're experts in this field. Can you give us, I hear the word probate, and it's like, it scares people. What is probate, and what are some techniques so that you can avoid it?
Okay. Probate is what happens when you die, when you have assets in your name without a beneficiary designation in excess of $25,000 cumulative. So what you want to do is, assuming you have assets in excess of $25,000, the trust is the way to go. As Patrick said, one probate is bad, two is worse, etc. So you create the trust, you transfer your assets during your life. That's why they call it a living trust, revocable trust, family trust, different terms for it. Something you create while you're alive. Typically, you're the trustee, you're the beneficiary, you do whatever you want to. And again, the trust acts as will substitute, says when I pass away, it goes A, B, C, D, and you name somebody to do that. So concept here is sometime in the next 100 years, you're probably going to die. But the trust doesn't die. The trust keeps going, and so you don't have to go through the court system.
Okay, and here's a personal question. I'm married. My wife and I don't have any kids. Do we need a will or a trust, Deb?
It depends. Do you want the state of Nevada to dictate where all your hard-earned assets go if something happens to you and your wife?
Of course we don't.
Well, then you definitely would need a will and or a trust, depending.
And for clarity's sake, we do. And we're actually all set up on our charitable designations and everything else. And I encourage other people to look at that as well. One last question here. Can you, in dealing with pets, and Patrick, I know we've discussed this before.
Yes.
Can you leave something for your pets in your will or trust? Go ahead, Patrick.
Yes, actually, there is in Nevada law something called a pet trust, where you can't leave the property to your dog, but you can set up a trust for the benefit so that as long as your pet is alive after you passed away, someone will take care of them, make sure all their needs are met. And so one thing to consider, that only lasts as long as your pet is alive, and then you have to figure out what to do with the remainder of that money. So it's good to have a secondary beneficiary, which can be a charity like the SPCA or Vegas PBS.
Thank you. Rob?
Yeah, we had a client in last week who it's good to do what Patrick said, to have those provisions, because what this client did is they said, here's $10,000 and the cat to so-and-so. I got a call last week from so-and-so saying, do you want a cat? I'm keeping the cat. Yes, no, I'm allergic, and that's unfortunate that, they didn't set it up in the way that they could have prevented that. I've set up a trust for a parrot, like an 80-year life expectancy, so these things can...
Excuse me, did you say parrot?
Parrot, yes, bird.
Okay.
Bird. Yeah, so...
And how did that work?
The parrot's still around.
Still making distributions, huh?
Still squawking.
Patrick, you made a great point about you might have your trust set up for a pet, and then there's some leftovers on top of that. What are some estate benefits of leaving a gift to a charity? Rob?
Certainly, you can direct where you want your assets to go. For example, I encourage people to, whether it's 1% or 2 or 3 or 5 or 10, just set a certain aside amount for charity. That way you can do something good. Not that the kids don't deserve it, but if you have 3 kids, 30% each is fine. You can direct where you want your estate to go to help further purposes that you approve of, that you like, you're in sync with.
And you make a great point there on percentages too, because a lot of people get scared or they're hesitant to put in a will or a trust. We're actually going to do a poll before in the live portion of this, so we will know how many of our viewers have a will or a trust, and we can talk about that more in the live portion of this. Then the last question I have on wills or trust is, how hard is it to change one? Deb?
If it's a what we call a revocable trust, a living trust, it's not hard to change. You just call your attorney and they'll do an amendment, or they can do a slap-on addition to the trust. It's a little bit different if it's irrevocable. Irrevocable means basically once it's set, it's set. But there are things that can be done to change an irrevocable trust, but you're going to want to work with a qualified estate and tax attorney to take care of that.
Thank you. Now we're going to totally change things up a little bit, and we are going to talk about powers of attorney and how important those are. We will actually have a sample form for you in the materials that you'll receive. You'll see them on the side of the screen here. But let's start with you, Patrick. What is a power of attorney?
Well,
that's a loaded question.
Very simply, a power of attorney is just a legal document that allows you to name someone called your attorney-in-fact or agent to act on your behalf. And that document is going to set forth the authorities or powers that you are granting to that person.
Okay, and is there more than one power of attorney? I think, Rob, you mentioned that before.
Yes.
Patrick?
Generally, there are two types of powers of attorney. There is a financial or general power of attorney, and there is a healthcare and medical power of attorney. Now, a financial power of attorney you can use to give your agent the authority to engage in transactions like real estate or insurance or banking. For example, not long ago, I acted as my sister's agent under power of attorney to sign closing documents on a refinance for her house because she was out of the country. It could be as broad or as narrow as your needs are. A healthcare power of attorney allows your agent to make medical decisions for you, and those are going to be guided by your wishes as set forth in Advanced Healthcare Directive or Living Will. And your agent can only make those decisions when you cannot. So if you're lying in the hospital bed telling the doctor, I don't want any more of the medication, it's making me ill, your agent can't be on the other side telling the doctor, yeah, go ahead, give it to him anyway. It doesn't work that way. And it's very important to know that you need both kinds because they're not interchangeable. So for example, if you had a financial power of attorney for your mother, you could not use that to make medical decisions. And if you had a healthcare power of attorney, that wouldn't allow you to access her bank account.
Got it. And Deb, I think we talked about this in a previous session where that's not necessarily the same person, correct?
Not necessarily, because a lot of times from a trust standpoint, or trustee, we can get called in to act on behalf and take care of the finances, but we cannot act and take over for the health care of a person. So a lot of times they are someone different.
And I'm sure all of you have experience in this area. Can you give me a positive experience with filling out the powers of attorney and getting it working well, and then again, one of the challenging experiences? Let's go ladies first, and then Rob, and then Patrick.
I'm probably not the right one to ask because typically we don't get too involved in powers of attorney as
Gotcha.
as a corporate trustee. I can tell you a personal story if you're interested.
Sure.
We're in the process right now. My 90-year-old father-in-law, as of last week, was declared legally incompetent. We had to get a letter from his doctor. So what that meant is, from a trust standpoint, now his successor trustee had to step up and is now in control over all the assets that are in the trust. We had to, that invoked the powers of attorney, so the healthcare power of attorney and the financial power of attorney, but the financial power of attorney really isn't coming into play because all the assets, they did it right. They made sure all of their finances and all their brokerage accounts, their houses, all their marketable securities were retitled and already in the name of the trust. So it made it much easier because now we have to put Grandpa in a home and all the documents are done, and it's just a matter of the person that was named, the agent, and the successor trustee just literally stepped up and is starting to make all the decisions.
So I have a story, again, from my personal life. A little over 2 years ago, my father-in-law was in a traffic accident and suffered a traumatic brain injury. And when we got to the hospital, he didn't even know who we were. But we had those powers of attorney, thankfully. So with the healthcare power of attorney, the doctors were able to discuss with us otherwise confidential medical information, and we were able to participate in his plan of care. Also, we had the general financial power of attorney, so we were able to talk to his bank and his insurance company. We were able to go down to the tow yard to get his car. Having those powers of attorney was like having a golden ticket. Because if you find yourself in a crisis situation like that, you want to be able to act immediately and take care of what needs to be done and not worry about, well, how am I going to get the authority to do this if no one will talk to me?
Rob?
I've got some of each of the stories. So
Please.
I guess the important part here is to get this in place before you have the need, okay? And we all three of us have the thing with our parents. So my father passed away a couple years ago after 12 years of Alzheimer's, okay? At the beginning, he was pretty high functional. He also has a white-knuckle death grip on all the finances and everything. And so we had this in place before Dad started his decline, naming my mom as power of attorney and children after that. And so at the beginning, it wasn't such an issue. Towards the end, Mom was able to do whatever she needed to because the document was in place. Another case, right before I came here, got a call from credit union. Can you give us the information on this client, this person, because we need it? And it's like, no, we can't. We don't, you're not the client. I can't divulge any confidential information. Had this client had the power of attorney in place, somebody else to be able to handle this, that would be a piece of cake. Another client said, oh, the second spouse is now gutting the estate, doing all of this. We don't have anything in place to stop this. So it's just very important to get these documents with people you trust, people you know. On the financial side, particularly on the health care side, is important. Nevada has a lockbox and in the cloud thing with Nevada Secretary of State, so your medical power of attorney can be uploaded to the state. You can have a card that you keep in your wallet. So you're in an accident, you're in the ambulance, they can pull that out, they can access your power of attorney and be able to have your wishes honored, whatever it is you want to do. So it's just really important to get that in place.
Then the lockbox program is wonderful. It's administered by the Secretary of State. A few years ago, they added another document, which is a guardianship nomination form. So if there's ever a situation where someone files a petition with the court to gain guardianship over you, they can pull up, and only the court has access to this in the database, just like only a healthcare provider has access to your healthcare powers of attorney. But they can pull up this document and see that, okay, well, you know, someone has filed for guardianship over Jim, but Jim has filed this piece of paper saying that he wants, you know, his mother to be his guardian and not whoever is filing this. And the court ultimately makes a decision on whether you need a guardian and who your guardian is going to be, but they will give preference to the person you name in that nomination.
Let's say, for example, you have 3 children. And usually the way things work is your oldest is the one that you want to make your medical power of attorney. Let's say, for example, that you've already made them your power of attorney, and they start having some personal challenges and everything else, and they're not exactly the right person. Can you shift that to the second child or the first child, and how complicated is that?
That's very easy to do. This is one of the things that's great about having a power of attorney. You can fire your agent. You have control.
Okay.
You can revoke the power of attorney, or you can simply name someone else. Or you can, you know, move it around and say, well, now I don't want son number 1 handling everything. I want son number 1 to handle the banking, but, you know, my second child to handle the real estate, and my third child in a separate healthcare power of attorney to make the medical decisions for me.
Any of you have anything to add to that? No? Okay. The last question I have, and I think we might have already answered this, but I just want to clarify something on it. Is my Nevada power of attorney valid outside of Nevada?
Well, as Rob mentioned, it is something that is governed by state law. Now, I would say that under the Fair Faith and Credit Clause of the United States Constitution, yes, it should be. Because just like if you're licensed to drive in Nevada, you can drive in Florida. If you're married in Nevada, you're married in Ohio. It should be recognized. However, there are states that have laws that say, in our state, we will only recognize a power of attorney executed under our laws. Now, I think if anyone were to challenge that in court, it would be found unconstitutional, but fortunately, I've never been faced with that situation.
It's mostly a matter of expediency. Mm-hmm. You want to, if you're in the crisis mode, something happens, if you're in Nevada, you want to have a Nevada form that Nevada physicians, healthcare professionals know and understand and will immediately honor, instead of, oh, this is New York, I better call legal counsel, you know, stay under the gas for another hour or two or a day or two while I check this out. So.
And by the way, anytime you make a major change in life, like moving to another state, it's always a good idea to review your powers of attorney, your trusts, your will, just to make sure that they still meet your needs.
Mm-hmm.
Got it. Well, we're coming to the close of this. Time has really flown by. But what I'd like to do right now is what I call my final thought. So, ladies first, Deb.
Thank you, Jim. I would say my final thought is just based on my current situation, personal experiences. Please take the time to, when you have the faculties to do so, do your estate planning and communicate it to your entire family. These are my wishes. This is what I want to happen, and be very clear on it.
And I can't emphasize that enough. I'm an only child. My father passed away 6 years ago, but he had the perfect roadmap for not only his financial and medical aspects. I am the financial and the medical power of attorney for both my parents, but he outlined everything that I needed to do just to follow it so that my mom is taken care of right now. And Rob, final thought.
Similar to that is just do what you want to do. People are afraid, they're intimidated to go talk to an attorney. Most are very nice people, and you can have, typically the initial consultation is free. Come in, talk, see if it's going to work out. But you want to be proactive and get your wishes known, whatever they are. The family will honor it if they know this is what you want. They can like it, they can not like it, but they will honor what you said. The worst thing you can do is do nothing and open it up to civil war. Most people would rather burn it than have the kids or somebody fight about it. So just make it clear what you want to do, and that makes everybody much happier, easier, better.
Patrick?
I would say create those powers of attorney. It's very important. They serve a valuable function, and they save you a lot of trouble down the road. Couple of reasons. Number one, the biggest I'd say is so you can avoid guardianship. If you are ever in a situation where you can no longer handle your own affairs, judges don't like appointing guardians over you, and it's an expensive and time-consuming process that you don't want any part of. But the courts are looking for what they call less restrictive alternatives. So if you've already named someone to make decisions for you and the court doesn't have to, they're going to want to do that. It's also important because, and a lot of people don't realize this, in the state of Nevada, unlike some other states, your next of kin does not automatically have the authority to make medical decisions for you. Generally, and with certain exceptions, you have to have an agent or a guardian to make those decisions for you. So it's just much, much better to be proactive, set forth your wishes and who you want to take care of you.
Well, Patrick did a little foreshadowing for us. We are going to have a full seminar on guardianship and care providing. That will be in April of 2021. I haven't said Happy New Year to everybody. Probably should have done that first. But we are definitely running out of time today. If you have a question, and I'm sure you will, please put them in the chat box. We're going to be back in 30 seconds live with Rob, Deb, and Patrick to answer any questions that you might have. We'll see you back in 30 seconds. Have a great day.